It's difficult to get a letter like that. It shocks you. But I had faith in knowing what I was doing, advocating for the community. And I have three kids. My oldest never went into the public school district, but my two younger ones did. And I definitely feel as if I'm being bullied into silence. What I see here, I think there's a blatant disregard for the parents' will.
That voice was Alexandra Schweitzer. She's a mom in the Oconomowoc School District and essentially got a cease and desist letter for her comments about actions of her school district. Joining us on the phone line is Rick Esenberg, president of the Wisconsin Institute for Law and Liberty, who are arguing this case. Welcome to the show, Rick.
Thanks, Steve. How are you?
Good. So we played a little bit of Alexandra's comments there. In your mind, is this a school district that has gone too far and said, basically, you got to shut up and stop saying what you're saying?
I think so. So our United States Supreme Court decided a long time ago that although it's not impossible for public officials to sue for defamation, the circumstances under which they can do so should be very, very rare. They can only sue a citizen for criticizing them if that citizen knew what they were saying was false or acted with reckless disregard for its falsity. And the reason is because we don't want to discourage people from participating in the political process. And so they need to be free to say what they want without knowing that they're going to get a threatening letter from, a lawyer, which, will cause them to basically check out of the process. And here, there's no credible argument. There's really no argument that what she said was false, even if you disagree with it. And there certainly is no argument that she acted with reckless disregard for the truth.
Give us an example of what she was talking about. It obviously has to do with some of the course material, some of the books that the school district is utilizing.
So she was concerned that there were certain materials that were available to younger children over the district's computer system, and she raised that issue. She thought that the district had addressed it. She kept hearing that they hadn't. She kept hearing about a book that was read in class that she thought was age inappropriate. So she raised that issue with some of the school officials, including the board president, and she didn't really get a straight answer. And so she testified before the legislature, which itself is a privileged setting, about her experiences with the school district. And there was a blog post later on in which she related some of the experiences that she had. And, you can disagree with her if you'd like, but this is kind of the ordinary give and take that we have between citizens and local officials. I know you've been a local official. I'm sure you've been on the receiving end of some stuff that some you probably appreciated and some you didn't. And but the answer is to respond to it if you don't like what she said, but not to go and lawyer up and send somebody a big scary letter from a big law firm, threatening litigation against them, particularly when and they have to know, that they're not going to bring this case because they can't possibly win it.
So it was a scare tactic, basically. Is that what you're saying?
Yeah. So the point of our letter is to say, look, guys, just stop. Right? We've heard about this happening to other parents in other school districts. And this really isn't the way to go about, managing the give and take between school boards and parents, right? If you don't like what she says, point out why she's wrong. But unless, she knew what she was saying was false, or you can prove that she acted with reckless disregard of whether it's true or false, you don't threaten people with defamation. So this is what Donald Trump wanted to do. He wanted to open up the defamation laws so that, politicians could sue people for criticizing them. And That's not what our First Amendment permits. I went to CPAC in 2016 and denounced Donald Trump for saying that. And I'm going to be consistent here with respect to the school district.
So are there reasonable limits to what a parent could say either at a meeting, whether it's a state meeting, state-sanctioned meeting, or a school board meeting? Are there limits to what they can say? I know you can't threaten violence.
Oh, sure. You can't threaten violence. She didn't do that. And with respect to defamation, you can't get up and knowingly lie about somebody in a way that's defamatory. So, if I I get up and I say, to the mayor of my town, that, I think you've been committing armed robberies across the state, and I know that that's not true, or I don't have any basis for saying that. That's something that's not permissible, and I shouldn't be surprised if I get a little pushback on that. But that's not what happened.
Why? I guess just looking at it from the the school perspective, why don't they just listen to the parents? They can agree or not agree, and then just move on. I don't know why this requires a attorney or a letter to be sent. Everyone has their opinion as long as they follow acceptable guidelines for behavior and content. I don't know why this has to take the next step and be also adjudicated in a court, or at least the threat of that.
It doesn't, and I think unfortunately it's kind of a sign of the times that we live in, where people are constantly attempting to weaponize the criminal law. And so Democrats want to lock up Republicans, and Republicans want to lock up Democrats. And I'm not saying that politicians never do anything that warrants that type of response, but mostly they don't. And we've recognized in this country for a long time that the remedy for speech that you don't like is more speech. It's not to threaten criminal prosecution. It's not to threaten people with violence. It's not to demonstrate outside their house. It's to point out why they're wrong. And I think we've lost sight of that.
Yeah, it's also really not less speech, which is one of the things this is kind of saying. We don't want you to talk. I mean, less speech is not the answer either.
That's right. It's not. And I think I think we've lost sight of that across the board. And I think our letter on behalf of Allie, which is basically to say, look, she's not going to retract what she said. She doesn't think it was false. She certainly didn't act with reckless disregard for her truth. She's going to participate in the process. And if you want to criticize her, fine and dandy, you're free to do that. But this type of threatening letter is crossing the line.
You mentioned that you've seen this happen in other places. How widespread is this threat of taking someone to?
I can't document it. My perception is that it's becoming more widespread, and to me, it's kind of part and parcel of what seems to be a kind of a disturbing lack of willingness to kind of tolerate disagreement. And so, if somebody comes out and it says the wrong thing, they got to be fired from their job. They have to be, we have to send people in front of their house to demonstrate. Even have to threaten them with violence and or threaten them with lawsuits, as we did here. And I just think that 99.9% of the time, that is the violence, of course, is always a wrong response. But this type of legal threat is rarely justified.
Rick Esenberg, President of Wisconsin Institute for Law and Liberty, joining us.